Hello, this is Ali Cem Budak from Istanbul Commerce University Law School. We meet today for our traditional science and society meeting. And as our guests, we have Constantin Eschlböck from Austria, an outstanding lawyer involved heavily in arbitration and ADR, who will be presenting us a talk, friendly talk on ADR matters with reference to Austrian legal system. Before then, that I would like to leave the floor to Dr. Zaim, Professor Dr. Zaim, for a few words he would say us to introduce the webinar. As you know, we call it webinar now. Web and seminar being connected. Go ahead.
Okay, thank you very much. First of all, I would like to thank Mr. Constantin for accepting our invitation. We wish to host him personally in our university, of course, but due to this unextraordinary situation, for the time, we are virtually meeting with Mr. Constantin, but we are hope to host him in our university personally. And we would like to repeat this, in fact, webinar as a real seminar afterwards, after this COVID-19 situation goes on. So for the moment, unfortunately, due to these circumstances, we have to go through the web environment, in a virtual environment. As we know, as Istanbul Commerce University, we start organizing a series of meetings entitled Science and Society Meetings. And this is the 7th of these meetings. And Mr. Constantin is, as Mr. Dr. Budak mentioned, is a very well-known professor on this area. So we would like to listen to his speech, and we would like to learn about this situation, especially while we are going through an extraordinary situation with COVID-19. We know that everything is changing in this moment, and in this changing environment, what we have to do with these proper problems on this area. So I'm not familiar with the area, of course, so I will not go long. But I would like to let Mr. Constantin to give his speech. And again, thank you for him for accepting our invitation. I hope to see you later on personally in Istanbul Commerce University. Thank you very much.
Thank you, Professor. Thank you for honoring our Science and Society meeting. I would say a few words to start with about Constantin Eschlböck himself, which I gathered from internet. He's an international dispute resolution practitioner based in Vienna, graduated from University of Salzburg, enrolled in Vienna Bar. After his apprenticeship, his years as a journeyman led him his way to various major courtroom and ADR battles throughout Europe. He thus gathered the experience to eventually establish his own firm in summer 2012. Besides trading as a general legal practitioner, particularly in fields of estate, probate, trust, and property, Constantin is sought after for his corporate advisory skills. The vast and continuous experience in contentious lawyering strengthening his recognition in the field of ADR, criminal and civil litigation among clients and peers alike. He has been a member of Ethics Council of the Vienna Bar since 2010, in which capacity he has investigated, heard, and ruled upon an ever-growing number of current around 150 cases. Since 2017, Constantin is a door tenant with Thomas More Chambers in Lincoln Inn Fields. Along with frequent appointments as an arbitrator, he is a regular attendee of various moot court competitions, especially the BIS moot and the FDI moot. Constantin is also involved in the UNCITRAL working group through Forum for International Conciliation and Arbitration, because he's a member of the board of directors, and he has been involved in working groups, including the topics such as enforcement of international mediated settlement agreements, enforcement of settlement agreements, investor-state dispute settlement systems, etc., which are all relevant to ADR, which we will be discussing today. Constantin is a consultant at LexMethods, a pioneering international consulting firm, also based in Turkey and Commonwealth of Massachusetts. So he has a great background and great knowledge on these fields. Let us hear what he says. Constantin, please.
Many thanks, Professor Budak, and many thanks to you, Professor Time, for affording me the opportunity to speak to you, especially the view to traveling to Istanbul and to meeting you in person is very honoring and means a tremendous lot to me. We have agreed upon taking a closer look at alternative dispute resolution and mediation in Austria today. Why do we need institutionalized dispute resolution at all? Why do we need a procedure? I trust that as in Austria, the same in Turkey, the need of parties to overcome that difference by virtue of a third person, or be it a judge, be it a mediator, be it an arbitrator, is considered a social wrong. Parties, as soon as they fail to achieve the goal of resolving the disputes among themselves, are in need of a third party. It cannot be disputed that parties, that the best resolution to any dispute is the resolution that the parties find by themselves. Mediation, among others, is meant to be the means by achieving this, by reaching this goal. Alternative dispute resolution is thus considered as an alternative to the old punch and run game of a decent courtroom brawl. Alternative dispute resolution has become an increasingly important and necessary consideration as an alternative to, in most cases lengthy and costly state court litigation. Various jurisdictions acknowledge what can be called the overriding objective of civil litigation altogether. It means that all steps in litigation must enable the case to be conducted justly, expeditiously, fairly, and proportionately. In many, if not most countries, courts have a duty as part of active case management to further the overriding objective, which includes ADR as a method of dispute resolution. In the territory of the UK, for instance, see Article 1.4 of the Civil Procedure Rules for Austria, among others, the Act on Resolution of Civil Law Disputes by means of mediation, the so-called Zivilrechtsmediationsgesetz. To achieve the goals of the overriding objective, legislation provides for adjudication boards specialized in their respective fields: tenancy disputes, disputes between energy providers and customers and suppliers, etc. To uphold the overarching principle of fair trial, however, adjudication board decisions are subject to judicial review in the state courts. Alternative dispute resolution, ADR practitioners, and among them, especially the providers of arbitration and adjudication services, claim that the advantages of arbitration are to, and I quote, to obtain the fair resolution of disputes by an impartial, tribunal without unnecessary delay or expense. Other jurisdictions, such as different from the one that I just quoted, which was, by the way, the Arbitration Act 1996 as enacted in the UK. Other jurisdictions, however, do not expressly provide for any such obligation of the arbitrator or arbitral tribunal. The respective measures are, however, often foreseen in the arbitration rules the parties to a dispute may agree upon, albeit only upon recommendation of an ad hoc arbitrator. See, for instance, for the realms of Turkey, Articles 9, 20, and 41 of the Istanbul Arbitral Center rules. Because of their specific experience and knowledge, arbitrators are deemed to ideally meet the requirements set out in these principles, which mutatis mutandis are similar around the globe to comply with the rule of law. The rule of law would be subject for a conference of its own. So I'm very much looking forward to coming to Turkey whenever we should pick up this topic. Critics, on the other hand, admonish that arbitration, with its typical fast track to judicial review, regularly fails to safeguard the procedural rights of one financially weaker party. I may refer you to the public discussion on the implementation of obligatory arbitral tribunals in international treaties, such as, in particular, TTIP and CETA. Following such criticism, especially arbitration as a means of dispute resolution faces far-reaching restrictions where consumer disputes are involved. For Austria, see the Civil Procedure Code requiring for representatives of the Workers' Chamber as well as the Chamber of Commerce if it comes to establishing arbitral tribunals hearing consumer cases. Well, the goals of ADR, as covered in the overriding objective, as we mentioned above, remain undisputed. A horses for courses approach should be taken in applying the various means of ADR in order to reach the actual aim, the resolution of the dispute. While there is no generally accepted definition of ADR, it has been said that a starting premise must be that alternative dispute resolution is a voluntary process and must therefore be consented to by the parties to a dispute. The glossary to the civil procedure rules in the UK is helpful by coining ADR as collective description of methods of resolving disputes otherwise than through the normal trial process. Generally, forms of dispute resolution can be distinguished in non-adjudicative and adjudicative, with the difference being that within the non-adjudicative form, the parties themselves, as mentioned before, come to agree to a resolution of their dispute, whereas in the adjudicative form, an arbitrator or adjudicator, in any event a third party, whom the parties either appoint or have appointed to find a resolution to the dispute, decrees the resolution. We distinguish different types of non-adjudicative types of dispute resolution. The non-adjudicative types, the recognized non-adjudicative types are negotiations or roundtable discussions, mediation as mentioned, conciliation, executive tribunal, and early neutral evaluation, abbreviated in E&E. Negotiations and roundtable discussions are mostly self-explanatory. Parties are always free and encouraged to find a solution to their dispute by themselves, by resuming or continuing to negotiate. Roundtable discussions, on the other hand, are negotiations in the company of the parties' representatives. Mediation is a confidential process that is conducted without prejudice to impending or even continuing litigation or arbitration between the parties. a party-appointed neutral intermediary endeavors to facilitate a settlement. The mediator does not act as judge or arbitrator, nor does he rule on the merits, and neither will he suggest or let alone impose the settlement terms. Mediation is often capable of achieving commercially sensible solutions, which can leave both parties satisfied. A court decision following great expenditure and the gloves-off approach might not achieve such solution. Even if unsuccessful, both parties are likely to benefit by knowing more about the strengths and weaknesses of each other's positions, which may eventually promote a settlement at a later date. The executive table, the executive tribunal, as mentioned before, is usually used to resolve commercial disputes. A panel is formed from senior representatives of the parties. Those representatives have not themselves been involved in the dispute. The representatives sit together with a neutral advisor. The process is similar to a mini trial, although it is not a trial at all. The parties present their cases to the executives, who then evaluate the respective claims. The board does not make a determination. Instead, the panel members endeavor to negotiate a settlement on a commercial basis. If they fail to reach an agreement, the independent advisor issues a, although non-binding, advisory opinion, which again may eventually lead to a later settlement. Under early neutral evaluation, E&E, a third party, mostly an independent legal representative, more rarely a judge, considers the issues and advises on the likely outcome. Having thus obtained the view of an independent advisor by both parties may have the effect of a spur to settlement. Among the adjudicative types of alternative dispute resolution, judicial or expert determination, arbitration, and adjudication should be named. Expert determination is comparable to arbitration. The parties jointly instruct and make a written submission to a senior lawyer, who will likely be a professor, as you two, of law with significant experience as an arbitrator or counsel. The senior lawyer then makes a written appraisal. The parties are required to agree the form and the extent of the instruction in advance, and whether the appraisal should be binding or not. From a practitioner's point of view, it is extremely important that the client and the parties understand the nature and extent of the instruction, especially if it should be binding, because the expert's appraisal will ultimately determine the case. These decisions cannot be generally appealed, but only challenged on limited grounds. In the event, for instance, that the expert has exceeded his jurisdiction or departing from his previous instructions. International arbitration, again, has become the principal method of resolving disputes between states, individuals, and corporations in almost every aspect of international trade, commerce, and investment. While critics, although, hold against arbitration as means of dispute resolution, that it is under constant suspicion of private justice or even judiciary in cabinet, they often forget that international arbitration only works because it is held in place by a complex system of national laws and international treaties. To name but the most prominent ones, I may refer your attention to the UNCITRAL model law, then highly sought after, particularly in the various moods, is the UN Convention on Contracts for the International Sale of Goods. This is what in the bar exam is very often asked to rule out, but in international treaties very often it cannot be ruled out. Even more important, the New York Convention on the enforcement of arbitral awards. I don't know whether this can properly be seen on camera. The most wonderful arbitral award will be pointless if it fails to get enforced in the country where it should be enforced. The key elements of international arbitration are the agreement to arbitrate. There is no arbitration unless the parties agree upon having the dispute resolved by means of arbitration. Thus, parties agree to have the dispute resolved by means of arbitration, usually by virtue of a more or less standard arbitration clause. For a very good example, see for instance the model clause of the Istanbul Arbitral Center as displayed on their website, obviously. Then there is the need for a dispute. As clear as this may seem, very often there isn't any dispute at all. For instance, if a contract has been performed and one party just fails to pay for it. If for instance, a check bounces. In this case, there isn't any dispute, and the absence of a dispute may cause the lack of jurisdiction of the arbitral tribunal. As unheard of as this may seem, it doesn't happen as unrarely as one may think. Then there is obviously the need for the appointment of an arbitrator or an arbitral tribunal subject to the underlying dispute resolution and arbitration clause. Then there will be arbitral proceedings, an arbitral decision, and eventually its enforcement. Of limited importance, at least in continental Europe, is the Dr method of adjudication. It is a process frequently used in construction and engineering disputes, both between contracting parties and professional advisors, such as architects and engineers. It is very popular in common law countries, above all the US of A and the United Kingdom. More often than not, no lawyers are involved in adjudication proceedings. They are very often conducted and determined by experts, particularly if it comes to the question and dispute whether a certain construction has been properly performed as required by the underlying agreement. The benefits of ADR are numerous. Litigation conducted in an adversarial or combative manner can prove time-consuming and expensive. The process can last many months or even years, if not forever. Because the parties are vying to win, litigation can end up driving them further apart. ADR should, on the other hand, and then again, not be deemed as a panacea. It is, however, true that it has a number of major attractions. Above all, confidentiality is to be named. Imagine a corporate dispute between, say, the shareholders of a company being carried out in public, in a courtroom. Imagine the lawyers being there, producing themselves, finding and searching issues that weren't there in the first place, just in order to get more media coverage or media coverage at all. It may thus be in the utmost interest of the parties to have a professional approach to the resolution of their dispute, particularly in the event where the parties have to coexist afterwards. ADR and mediation in particular is relatively inexpensive by comparison to litigation. Most forms of ADR with regard to meetings and hearings hardly take more than a day or two. Complex arbitrations may, however, get lengthy. That is true. Within non-adjudicative ADR, parties do not, and this may be one of the most crucial topics, parties do not confer and therefore lose control over their dispute to a third party. Retention of control may be the most important reason militating on behalf of particularly mediation as means of dispute avoidance rather than dispute resolution. Some countries, with, as I have learned, Turkey among them, have thus imposed a mandatory mediation stage prior to initiating certain commercial or employment disputes. And for the students watching us and for their certainly bright future careers as lawyers, I may give you a drafting hint. Especially when it comes to drafting international agreements, it may amount to malpractice to not at least try to implement a dispute resolution clause providing for arbitration or whatever means of dispute resolution. What we often see are so-called multi-tier dispute resolution clauses, starting with a mandatory negotiation stage, moving on to a mandatory mediation stage, in the event of failure of which people then go on to either litigation or arbitration. Even if legislation may provide for your home turf venue, so even if you avoid a dispute resolution clause and succeed to get the other party to agree upon the commercial court in, let's say, Istanbul, the absence of an enforcement treaty between, let's say, again, Turkey and any other state, so the state where the opposing party is domiciled, may render your verdict of the state court in Turkey useless. Too much caution and skill, therefore, cannot be observed in negotiating and drafting the dispute resolution clause that, among the uninstructed, is mockingly referred to as part of the midnight clauses. The dispute resolution clause, together with all the other clauses that usually are numbered by Roman 20, etc., are referred to as the midnight clauses because they are negotiated during the night, where the negotiators usually not pay as much attention as they did when it came to negotiating the reps and warranties. The dispute resolution clause may be decisive and crucial. Many, many thanks for your kind attention. I hope that I reached the aim of giving a short overview on the means of alternative dispute resolution. So should there be any questions or should there be the interest or need for discussion, I'm happy to continue. Many, many thanks.
Many thanks, Mr. Constantin, for your marvelous talk. I was planning to say some words to introduce your speech at the very beginning, but then I was not sure about the time management of the webinar, so I did not do it at the very beginning. Let me say a few words, which was my first intention to say. To put the matter maybe into a historical perspective, historical context, because the dispute resolution matter is highly related to the zeitgeist, as people say, to the time and to the historical development. The history of civil procedure, when we look back to the 200 years of history after the codification in Europe, starts with the French experience, the first civil procedure code of Europe, which adopted a very liberal approach, and which left the initiative to the parties, giving a large playground to the parties and less involvement of the court to the dispute, less initiative to the judge when hearing the cases. It took some 100 years until the Austrian civil procedure code appears, which takes another approach, social civil procedure approach, which provides for an active judge and judge taking care of correct proceeding of the case. A third milestone may be the developments after the Second World War, supported by the New York Convention of 1958, which is another important milestone, during which arbitration, especially in the field of international dispute resolution, becomes prominent. And it took another 2 or 3 decades where we come to a stage of thinking about alternative dispute resolution methods, to use more actively alternative dispute resolution methods other than arbitration, because it appears that it's understood that arbitration may also be quite expensive and quite time-consuming. And business people especially are interested in resolving their disputes on interest basis, rather than trying to prove they are in the right side of the dispute before the court or before the arbitrators. So mediation appears as one of the most effectively used dispute resolution methods, and a coincidence is a happy coincidence is that Turkish mediation law has been partly borrowed from Austrian law, from Federal Civil Mediation Act of Austria, and I was involved in the preparatory stage of the legislative studies, and we visited Vienna and also UNCITRAL premises for the preparatory work, and as the UNCITRAL law the base of Turkish Mediation Act in principle, but there are several articles borrowed from your law, especially when it comes to organization and training of the arbitrators or the mediators. In Turkey, for the time being, an important aspect of mediation discussions is that in certain commercial cases, as well as labor disputes and employment disputes, as Constantin said in his talk, mediation became mandatory as a first step to initiate court proceedings. There are critics about that, but it appears that mediation, the field of application of mandatory mediation, will extend in the years to come. And for that reason, it will remain as a hot topic in years to come, in the next 5 years, I believe, during which we may organize a real seminar, a live seminar, where we would be pleased to see Constantin with us, and maybe know each other personally more closely. So let us give the opportunity to our audience to put questions if they have. But before then, that maybe Constantin has something to add to conclude.
What is true that as you pointed out correctly, and this is the impression that I got. I have to admit that when mediation entered the market, like 10 years ago, I was not immediately sure what to make of it. And I wasn't, as it became more and more popular, I wasn't sure whether the parties weren't expecting too much of it. It was obviously popular because it was way cheaper, as you mentioned, than the conventional means of dispute resolution, such as litigation and arbitration. What I have, however, learned by the time, as time passed by, is that it is always horses for courses, and it's always depending on the dispute, the nature of the dispute, and the parties, which means of arbitration are ideal in order to resolve their dispute. So rather than gloves off, it should be realized that the proper dispute resolution tool is like a glove, and there is the best fitting dispute resolution method for every dispute and for the parties respectively involved in the very dispute. So mediation will play a role with ever-growing importance in the near future, given the ever-increasing complexity of particularly international disputes. By all means, serving to reach the overarching aim, which is to uphold the rule of law.
Thank you. And let us give the opportunity to the audience to ask questions if they have. How does it work? Will it be written form? Ayşe Hanım?
Buyurun hocam.
Soru sormak isteyenler olursa yazılı olarak mı sorularını iletecekler?
Hocam biz size yazalım. Chat kısmına ileteyim sorular varsa.
Soruları iletin. Sorular olması lazım. Sorry for communicating in Turkish language, but they will put the questions through chat program.
Hocam şu anda birinci soruyu chat kısmımızdan paylaştım.
İstanbul Commerce University, everyone. So can you read it?
It's gone.
No, it's gone.
There was a bubble there, but now it's gone.
Çabucak gidiyor Ayşe Hanım. Onu biraz...
In Turkey, it's mandatory.
Let me try to...
Hang on.
Okay.
In Turkey, it's mandatory to apply for mediation in some cases, such as labor law disputes and most of the commercial disputes. Do you support this approach? Yes, I think I do. Particularly in constellations where the parties are required to coexist upon the resolution and determination of their case. Or do you consider the mediation as a cause of action, as time-wasting judgment process? No, it may be. The question is not entirely, the question is obviously justified, because I mentioned those multi-tier dispute resolution clauses where parties are required, not invited, required to trigger the jurisdiction of the next the next stage and the jurisdiction of eventually either the state court or the arbitral tribunal. So parties are required to go through the various stages, negotiation, and if negotiation fails after like 4 weeks, then you will proceed to mediation, which if to no avail, you may then sue them somewhere, and there will be another settlement institution. Those dispute resolution regimes may sometimes turn out to be ineffective, and we call this a pathologic dispute resolution clause. However, if the dispute resolution regime is carefully drafted and comply and according to the needs of the parties. So be careful with scissoring and taping dispute resolution clauses. If mediation is required and according to the needs of the parties, it is not only an option, but it is not only an option, but it is the option, and most certainly not cause of action, and most certainly not a waste of time. Subject to, however, depending on who is involved in the dispute resolution stages. If you get a notorious courtroom brawler who is after nothing but suing everybody for every penny they've got, then he will find that the mediation clause is an obstacle rather than anything else, preventing him from taking the matter to the court as soon as possible. So dispute resolution specialists, practitioners, and experienced experts, whom I would say should not be short of diplomats, are required in order to skillfully and sensibly apply those various means. As you know, in 2019, the Singapore Convention has been adopted and will enter into force in September 2020. Do you think this convention enhances using mediation in dispute resolution agreements more and provides initiating mediation before litigation, arbitration, and consequently make enforcement of settlement agreements easier, like the New York Convention 1958 for arbitration? Yes, obviously I think so, as this is the explicit aim of the convention. Not only do I think so, I do hope that this will be the outcome.
Since the question is to everyone, I would say a few words about the question if mediation is a waste of time. I'm basically a law school teacher. I'm not in everyday legal practice, but I happen to be, let me say, participant observer, as the sociologist says, in 3 international mediation cases. One of them was really unsuccessful and a waste of 2 days' time for a team of 5 or 6 persons flying from Istanbul to the United States. But the other 2 was quite successful, and the matter, the dispute, multi-party dispute with several parties, were resolved in a single day of work, which would take in court proceedings years, and for sure for months, for the arbitrators to resolve. As an arbitrator, when I am dealing with arbitration cases, I sometimes think that when the party submissions are collected together, a clever man, a clever lawyer, who spends 4 or 5 times on this file can resolve the matter, but we need 4 or 5 months to come to the conclusion, because to grant the parties the right to be heard, to observe equality between the parties, you have to be very cautious, putting time limits enough for preparing themselves, etc., which takes its time. Mediation is very speedy, very effective if the parties are well prepared and are really willing to resolve the dispute. It's not only a matter of regulation, of course. We start with regulating and imposing mandatory mediation in our law. But when the culture comes, when the people get used to it and believe in it, I think it would be a great help, and also it will be a great help to enlighten overloaded court procedures and serve for process economy as well. So, any other questions? Oh my God. Is it another question or the same? Last question.
Perhaps this also reflects what you said, Ali. While I am a very fervent supporter of dispute avoidance, so in my not only opinion, but conviction, the best way to resolve a dispute is to avoid it. So whatever it takes to facilitate to facilitate parties finding their own solution to their respective disputes is certainly justified. However, I am not sure whether legal training really focuses on the technique and the tools mediative or alternative dispute resolution provides. In Austria, when I look back to our training, it was, as I mentioned initially, the old punch and run game of litigation. Yeah. So in mediation, you normally begin. You have the set of facts as claimed by the claimant, and you have the set of facts as told by the respondent, and then you try to cross out the undisputed facts, boiling the entire dispute down to the disputed issues. So issue identification, no matter whether you sit as a judge in a state court in litigation or as an arbitrator or obviously as a mediator, issue identification is the first stage of every means of dispute resolution. And then you will quickly realize and soon realize that the dispute is about 1, 2, very rarely 3 issues. And if you take a closer look at it, you will realize that you can shrink what was seen, what began as the Third World War. You will shrink it down to life size. Yeah. And therefore, I do think that mediation does play an important role, particularly in the realm of issue identification and by crossing out undisputed elements of the set of facts. In litigation and with traditionally trained lawyers, you will, well, not always find this approach, because the lawyer for the respondent, representative counsel for respondent, will start his will start his pleading by A, I don't know the claimant, B, even if I knew the claimant, I would never have entered into a contractual relationship with him, C, even if there was the contractual relationship as falsely purported by the claimant, it doesn't have the effect that the claimant claims, etc., and so on and so forth. So therefore, diligent dispute resolution and diligent support of your client may help a great deal. I am, however, admittedly not sure how far the proclamation of this gospel has gone already. I therefore do really support every effort of proliferation of alternative dispute resolution, with mediation being one of them.
So it's important to be correct mindset, and a conservative, let me say in quotation marks, traditional legal training, law school years does not bring to the graduates the flexible approach open to mediation, arbitration, and alternative methods. What we do in Istanbul Commerce University Law School is to get familiar, at least our students, with ADR. It's a part of our courses as well. But the reason we chose this topic was also to enlighten our students or prospective students about the matter. Any other questions?
Hocam başka sorumuz yok.
Hocam başka sorumuz yok means Professor, we do not have any other. Okay. So I would thank you very much for taking the time. Seminar after the COVID.
It's on me to thank you for your very generous and very honorable invitation. Thank you to the amazing audience. And God willing, we shall see each other again as soon as possible, no matter where, no matter how, but healthy above all. And until then, the very best. Many thanks. Goodbye.